70 ಮಾಡ್ಲಾ ಈಗ ಅದು ಬರ್ತಾರ ಬಿಡ್ತಾರ 70 ಮಾಡ್ತಾರೆ 70ನೇ ಇಡೋದು ನಮ್ಮ ಮಾಮೂಲಿ 64 ಇಲ್ಲ ಆಯ್ತಷ್ಟು ವಿಡಿಯೋ ಪಾಪ ಆಗಿಲ್ಲಲ್ಲ ಸುಮ್ಮನೆ ಚೆಕ್ ಮಾಡ್ತೀನಿ ಈಗ ಸ್ಕ್ರೀನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇದ ಅದಲ್ಲ ಇದು ಹಿಂಗೆ ಮೂರು ಕಾಣಿಸ್ತಾ ಇದೆಯಲ್ಲ ಕಾಣಿಸ್ತಿಲ್ಲ 1 2 ಇಷ್ಟಿಲ್ಲ ಅಲ್ವಾ ಯಾವ ಇದನ್ನ ಹಿಂಗೆ ಹಂಗೆ ಬಿಟ್ರೆ ಅದು ಇವ್ರು ಬರಲ್ಲ 40% ಮೇಲೆ ಓವರ್ ಬರುತ್ತೆ ರೆಕಾರ್ಡಿಂಗ್ ಬೇಕು ಇನ್ನೊಂದು ಕಾಪಿ ಇದ್ರೆ ಕೊಡಿ ಮೇಡಮ್, ಅದಕ್ಕೆ ಕೊಟ್ರಲ್ ತರ್ಸಿ. ಎರಡು ಇರ್ತಾನೆ ಬೇಡ ಸಿಕ್ತು. ಯಾವ್ದು ರೈಟಿಂಗ್ ಕೋರ್ಟ್ ಪೇಪರ್ಸ್ ಇಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಯಾರೋ ಒಂದು ತೋರಿಸ್ತಿಲ್ಲ. ಕೇಳ್ತಾರದೊಂದು ಅವ್ರು ಎಷ್ಟು ಮಾತಾಡೋದು ಹಾಕಂಡ Yes. Atas matter, serial number 1, Maya Valla.
But I will not take more than 5 minutes. I have made my submissions. Just I have made a small compilation. It's same thing, but I, instead of searching for all documents, it is in one compilation.
At the end of the day, we will have boxes of papers.
There's nothing new in that, my lord. Only the rules and everything in one document it could be available. My lord, these 4 rounds, it is not available in rules. It is by judicial precedents. Lord, there is no dispute after first and second round. These people will not have right to participate in the consequential seats. This issue, similar issue, has come to the consideration before the Honorable Supreme Court in Bhavna Tiwari. Now, one specific direction I would like to point out from Bhavna Tiwari, Lordship may kindly have a look at page 63 of the bunch which I have given now. Now, only 5 documents I have given. In that, 2 sets of rules also have provided. Page 63, Your Lordship, last paragraph, paragraph 16. As held by us in paragraph 14.4, we issue the following direction to the concerned authorities. I'll skip 1, 2, 3. 4th paragraph, Your Lordship. Permit upgrade windows post round 2 for admitted candidates to shift to better seats without reopening council to new entrants. Here, Lord, we apply these directions to the facts of this case. Lord, these new seats which is added in between the second and third round was not available on the first date. My submission is, Lord, these 443 will have to be treated as the seats available on the first day when we participated in the counseling. So they should not have allowed new entrant to participate for these 443 seats. Only when we exercise this upgradation as per this direction, then these seats will fall as a vacant seat for consequential round. Therefore, because they allowed registration of new entrants for these 443, this anomaly has taken place. That is what the division bench has considered in para 38. The Justice Banerjee has taken a view. Kindly have a look at that para. Page number 70. Para 38. Yes. Lord Justice Banerjee's view, after referring to Bhavna Tiwari, para 37 and 38. Lordship got it? Yes. May I read para 37 and 38? Yes. Not para 37. Yes. However, just a minute. Yes. Yes, sir. However, the Supreme Court has been pleased to grant such relief and pass such orders from time to time in various judgments, and orders some of which are noted above, due to which the process of seat allotment in medical colleges is being carried in smoothly all over India. Therefore, the direction given by the Supreme Court in Bhavna Tiwari that upgrade windows post round 2 for admitted candidates to shift to better seats has to be permitted without reopening counseling to new entrants is the mandate that the respondents are bound to comply. Therefore, new registration for the first stage of third round of counseling for the 443 new seats could not have been made by KEA. Only the admitted candidates post second round of counseling would be entitled to participate in the first stage of third round of counseling. The third round of provisional seat allotments list of candidates dated 24/10/25 is therefore set aside with the direction to the KEA to undertake the process of third round of counseling afresh strictly as per the direction of the Supreme Court in Bhavna. In 2 stages. Yes, the operative portion says in 2 stages. Yes, because there are 4 rounds. Admittedly, there are 4 rounds now. Now, as per Bhavna Tiwari, another round is added, which is they call it as upgrading round. After second round and before third round, in between, for upgradation of these people, that round is available now as per Bhavna Tiwari. Therefore, the Honorable Larry Singh Judge had that sorry, Justice Banerjee had that, my lord. This process what the KEA has adopted, allowing new entrant to participate in for this 443 is bad. I also am not supporting this view. This is contrary to this.
All right.
Yes, that's-
Mr. Naik,
yes.
see, first you have graduate medical education regulations.
Yes.
Then you have Karnataka selection of candidates for admission to government seats in professional educational institutions.
Yes.
Now, combined reading of both these regulations give ample room to KEA to frame their own procedure for.
Yes.
No qualms regarding that. Now, some places it is 3 rounds, in some places it is 2 rounds.
Yes.
In our state, it is 2 rounds, normal thing. The 2 rounds thing, not for 443 seats, but the regular 2 round thing, you are not challenged.
Yes.
The regular 2 round thing, you are not challenged.
We are okay.
In your writ petition.
Yes, ma'am.
The problem comes in because of the infusion of 443. Now, for 443 also, if they had done the 2+ and done the mop-up, usually would not have any grievance. But 443, what they do is they do only 1 round.
Yes.
443, they do only 1 round. Then you have this, the 3rd round coming in.
My lord, my submission is these 4 rounds, these round 1, 2, 3, 4. Several judicial decisions, my lord, Bhavana Tiwari have not read full. My lord, if your lordship could see the judgment.
Bhavana Tiwari.
Yes, my lord.
Analyze the existing modality in the state of UP.
It is not only UP, my lord. It is not only UP. They refer to all earlier judgment of the Supreme Court.
Correct. But it pertains to more of
similar situation. In a similar situation, there also, my lord, kindly have a look at first paragraph, that para number 2 and 3. ಸ್ವಲ್ಪ facts ತಾವು ನೋಡಿದ್ರೆ it will clarify the things. Similar situation where, my lord, the lower ranked candidates got a better seat, and higher ranked candidate they did not get their choice.
now. Supposing there was no infusion in 443, then in that event,
We have no claim.
see at the end of round 2.
Yes.
At the end of round 2, if you see, you have to make a choice whether to give up the block seat and then come up for the mop-up round,
Yes.
or exercise your choice.
Correct.
Okay.
Correct.
You have to take a decision.
Yes. ma'am.
Now, supposing you take a decision not to give up the block seat, still there could have been a chance in the mop-up round where you would have got a better seat.
Yes.
You exercise your choice over there.
But I am not supposed to, because my right ends with ground.
Yes, proceed. Yes, nice.
As far as not the 443 seats are concerned, I was not permitted to participate. And on that, my lords, I don't have a grievance. Now, my lords, whether Bhavana Tiwari applies, whether my lords advocated as not a separate round, all that, my lords, ultimately, my lords, arguments have been made. My other grievance, my lords, is with regard to, my lords, that the vacancies that arose as a result of, my lords, people exercising, my lords, the choice in the 443 itself, which, my lords, according to them, is, my lords, approximately about 184 seats. Now, my lords, in respect of these 184 seats, it, my lords, again is pushed, my lords, into that second bracket, not, my lords, for me. And the strange thing, my lords, is that this consequential allotment or consequential vacancy, that is, my lords, which arose, my lords, in the process of the seat allotment itself. In, my lords, every other round, they, my lords, permitted those to be filled up in that very round itself. I just, my lords, point out that, my lords, the second round, the notification that they issued, my lords, for the second round, that, my lords, would find in their statement of objections, my lords, at page 16, my lords, in, my lords, WP 31934. of 20th August, Milords. Page 16. 20th August. I'll not straight away just take Milords to page 17, Milords. These were read out, Milords, the instructions that Milords would find at the bottom, Milords, of page page 16. I'll just straight away request Milords look at Milords point number 6, Milords, in this at page 17. Candidates can change or remove higher order options. In the second round of seat allotment process, the seats arising due to candidates taking up other seats are also allotted on merit basis, so that the candidates can retain their seats even if there is no availability of seats in the seat matrix. Candidates are advised to mention all the seats they are interested in order of priority. Then Milords, the note, that is Milords, after point number 7, also Milords, seems importance. Note, consequential vacancies that arise during the allotment after the candidate merit or turn cannot be claimed. So the corollary to this would be that Milords, until his turn, if Milords, there are any vacancies that arise in consonance with Milords point number 6, that candidate Milords is entitled to choose. It is only Milords after his turn is over. Milords, ultimately everybody gets a turn, Milords, based on their merit. To Milords choose whatever are the vacancies or the vacancies based on Milords their priority or choices or whatever one may call that. So until Milords it is his turn, if Milords there are vacancies that arise, they are Milords entitled. If a vacancy has arisen, Milords, after this candidate is given that choice, what this says is that is not available. So therefore, Milords, the consequential vacancies that arose in a round were, Milords, in the second round, Milords, it was permitted to be filled up in that round itself. Now, strangely, Milords, when it comes to this round, the third round, when it comes to these 443 seats, that option is not given to Milords, the candidates who, Milords, had seats in the first 2 rounds. It is given, Milords, only to the other candidates who, Milords,
so you're saying there's an arbitrariness because
Please, Milords.
in the second round, before infusion, the seats which fell vacant with others on top exercising their option, they were made available for you.
Please.
That should have been there even
in Milords, the third round.
Even in the infused seats.
Please,
and that not giving you that benefit is arbitrary.
Please, Milords.
Because it would be in consonance with what was offered in the second.
Please, Milords. Which is, Milords, their own procedure that they followed earlier. And Milords, the other thing, Milords, is also this. When it comes to, Milords, every other, Milords, category of seats, Milords, engineering, architecture, the Indian systems of medicine, the third round, Milords, has this consequential vacancy, Milords, being allotted to, Milords, everybody. I have not produced that, Milords, at page 233 of my petition.
Milords,
31934. Milords.
Page number 7.
This is page number 233, Milords, 233.
Just
Annexure AL2. Annexure?
This is, Milords, annexure AE, Milords. At Milords, page 233.
yes, sir. Eligibility.
Milords, this is, Milords, what, Milords, this is 6925. This is UGC 2025, third round seat allotment for, Milords, engineering, architecture, veterinary, agricultural science, pharmacy, BSc nursing, yoga, naturopathy, BPT, BPO, allied health sciences, etc., including UG Ayush courses. So, Milords, it's for everything other than, Milords, dental, Milords, and medical. So there, B, Milords, at page 233 is, Milords, the instructions to all categories of candidates regarding entry of options for the third round of seat allotment. There, Milords, point number 3, Milords. Further, seats will be considered for allotment as a result of any consequential vacancy that may arise during the seat allotment. So, Milords, again, when it comes to, Milords, every other, Milords, category of seats other than, Milords, medicine, they say, well, if there is a vacancy that arises in the seat allotment process, we will fill it up in that round itself.
That was also extended, made available for the second round.
That is also, Milords, for the second round. This is not, I'm saying in the same third round, what happens is they,
All this
every round,
we are examining all questions only because of infusion and the procedure that is followed.
please. So I'm only not saying that this
Your cases, if second round permitted consequential vacancies, the round after infusion for those infused seats should also have permitted consequential vacancies. But after you chose, you are exited, and whatever was consequential vacancy have been offered to the new entrants, and the others, therefore, though less meritorious, they take better seats. That's the case. So that's the addition. That's another aspect that you point out to what Madam is pointing out.
At 1.4, the WP number 32519. Facts rest on the same issues.
Just a minute.
Yes. Consequential is intermediate vacancies and intermediate in the 440.
Yes, there's a little buffering that is
Yes.
taking. Give us a second.
Yes. More on the facts, facts are we are all in the same situation where ultimately less meritorious ended up in getting these 443 seats.
Now, there are twofold submissions. One, according to Madam Vidyulata, even the consequential seats should have been offered along with the infused seats. That is first fold. The second fold, and she is supported by Mr. Nayak, Mr. Vivek, is they could not have been exited after the first part of the
That is precisely what we are.
first part of the counseling for the casual vacancies.
Yes.
That's they say it is arbitrary.
Yes.
Firstly, on the ground that it is discriminatory.
Yes.
Secondly, as Mr. Mr. Vivek was pointing out,
Yes.
this is a choice that is available in the second round.
Correct.
This is a choice that is available in the other streams
Yes.
or disciplines,
Yes.
even for the third round. Therefore, there is no reason to exclude.
Yes.
That's Mr. Nayak says upgradation is part of is something that they are entitled to
Yes.
in terms of the Supreme Court's directions before the new entrants are permitted to. Correct, Mr. Nayak?
Correct.
So these are essentially the threefold arguments that are present.
But on the question of discrimination and equality, there will be only one issue. There should be a level playing field. Whatever may be the rules or whatever may be the intermediate arrangements they make in view of the influx of a 443 seats. Assuming 443 seats came, they now have to distribute it. Whatever they do must have a level playing field. And it should have a semblance of
Is it
equality.
level playing field or primacy to merit? Because
Yes, a primacy of merit. But level playing field, by that I mean, there must be primacy of merit. That is what ultimately it should answer that test. And if it answers that test, then it is fine. But it should not result in a situation.
Does it or does it not?
It does not.
Why
It does not.
say?
Because ultimately, all of these petitioners, we have the chart, all of these petitioners have lost the 443 seats to persons with lesser merit and lesser
I don't know how Mr. Ramesh would meet all these submissions subject to that caveat. If we were to ask you, sir, that one of the to ensure that merit prevails, they have devised the options identified for once.
Correct.
And that identification of options is made sacrosanct, because that will decide, that will be
Perfect.
the rule.
There is no
defining-
human interference.
That is the game defining rule. And so long as we stick to it and everything else is worked around that to meet certain exigent circumstances, there's no arbitrariness could be one, because Mr. Ramesh has been emphasizing when in the initial opening round, as we would call it before us, that we give them the option of making their choice. Once they choose, that is frozen.
Yes.
And within that choice, all the options are thrown up
Yes.
in the first round, in the second round. So some seats may arise, some seats which are more beneficial may arise. But if they are not part of your options, we will not use the word choice because choice is another.
But all this amounts to, all this zeroes down on how they have made the software. Ultimately, human beings make the software. And if they have arranged the software, it is a pre-built software, which they are using for this new situation of 443 seats. So what they ought to have done, my humble submission is, because I watched their arguments before the previous bench, what they ought to have done was, this 443 should have been taken with the old contestants, the old persons who have participated in the first two rounds. Even though it was a third round, etymologically or in common parlance,
It is not effectively a third round, it is a first round.
It is a first round. Because they brought in these seats, they should have limited the contestants or the applicants to those persons who were already in the race, exhausted this, rerun the first and second round or only one round for this, and then moved on, taken the balance seats to the mop-up round. What they did was, they brought in the exterior students who had not applied in the first two rounds. They brought them into this field, and they brought the existing students into this field. By this, I think the software itself has got confused. It has treated all of them as one and the same, perhaps, because ultimately software is human built. We don't know.
It's a logarithm, isn't it?
Yes.
It is not.
What I have done. As I repeatedly submitting, I'm sorry for the taking the patient.
Let's senior complete man.
Yes.
Let's senior complete.
And then in that process, when that was brought, they have taken us for one round and we have been ejected.
That's what
exit. That exit is the area where even they cannot control nor we cannot control because of the pre-built software.
Now that
How
is
the
why,
software is
that is why we are asking if they have as a consistent adherence to the rule that you choose and we let you go by that choice alone. How do we say there is?
But then what would be?
Because something could have opened up,
Yes.
but it may not be within the zone of your choice.
Yes, but what would happen is
For
this.
your
I
option.
understand what your lordship said, pointing out. What would happen is this. The software is already made and it is with them. We are not concerned about that. Point is, when a new situation or a circumstance arises, the way they address that situation is the only issue here. And what they have done, they should have allowed this fray to continue, this competition to continue with the existing participants and taken the balance that is there in the 443 into the mop-up. They should have treated that's a clean definition and
So they have not done is a fact.
is a fact.
They have not done is a fact. Now, the legal argument by your younger friends is that legal arguments by your younger friends are it's arbitrary.
Yes.
Well, these are new seats for all purposes. If they permitted casual vacancies in the second round, they should have permitted casual vacancies even in this round before locking out the others.
Yes.
Essentially, and of course, Mr. Naik.
That is all we are trying. And that arbitrariness is because they did not adopt. They should have taken it as two segregated fields and first finished this 443 with the old method and then gone on to an overall mop-up with the 440. That they did not do, right? Which is not created the level.
Let us hear how they defend. Mr. Saudi may not have anything to say. Just nothing on it. So you nominate KEA and you admit that they have the elbow room. They have the elbow room to adapt to an emerging situation.
And one,
In the new jam, we only nominate them,
And they have the elbow room to adapt to emerging situations subject to merit.
now, my lord, one last submission of mine is, due to the KEA mixing the mop with this 443, what has happened is, this is practically what has happened. The mop-up considerations and choices, which the computer took, and the 443 choices which it took from the old participants, who are about to leave the existing places for these 443. By combination of all this fault has occurred. Because perhaps the software has treated them as one, but we human beings are treating it as two. But the software has treated them all as one and given the result. So this they should not have done. That is where they are lacking in.
They have not done is a fact.
They have done is a fact.
Whether there is
They have done is a fact.
whether there is a cause, ultimately we want to know whether there is a cause, whether that cause can be entertained
Yes.
at this stage.
Yes.
Of course, Mr. Nayak says it's only a initial list, not the final list.
Yes.
We will consider subject to.
Yes. And still there could be permutations. If we allow this list to run today, still there could be permutations where people will leave this round and join other. So therefore, it is retrievable. We can address this situation, ensure proper ranking, and then proceed. Please, it should be taken to its logic.
Yes, sir. Now,
Apply.
we will also consider that though this is a provisional list, not the final list, those who stand to benefit are not before us in the present proceedings. Are not before
But
us.
sir, there is a stay and they are aware that the proceedings are pending. Since about 3 weeks or 4 weeks at least, 1 month at least, they should have come now and try to address their grievances if any.
Well,
And it's only a provisional list.
we'll definitely consider that.
And
That
since
is
it
also
is
something-
perhaps since it is provisional, they are also waiting for it to take shape, final shape.
Yes. Yes, Mr. Ramesh. Now, all others versus you as it emerges, sir.
Lord, here, first thing what I say is, Lord, the facts are not in dispute. These are the students who have entered first round and choice two. Choice two means I hold this, first round they got a seat, they hold the seat, they go further. They came to the second round. Second round, we allotted a seat. And during the second round, 400 seats came. Additional seats like this only. That was also the benefit was, my lord,
400 or 100?
400. Second, total, second round. Second round. I'm sorry, my lord, I stand corrected. Total seats. 853 seats.
New addition only 100.
Addition. That also we have given. That benefit also they have reaped. Then, my lord, we have our regulation rules. Rules, my lord, your lordships have already seen, my lord, that the notification, first and foremost, my lord, my friends were saying there is nothing was published. All that, my lord, your lordship may kindly take, not the thing which everything is available in this, all notifications. Spiral bound.
Second.
But I'm sorry, I had made a synopsis of arguments, I just ran it. kindly take minute to stand by me. There, Your Lordship, may kindly take page 69. We have as many as 3 minute brochures were published. Page 69.
You call it bulletin
Of the brochure, got it.
69.
Of the spiral bound minute.
Yes, 69.
Then what? This is the notification by the NMC under which minute we operate.
They are nominated.
Then down below, Your Lordship. Online seat allotment. Information about the online seat allotment along with instructions, procedures, guidelines and schedule for each round will be published in the letter in KEA website. So, my lord, because these are all procedural laws, it goes on changing, my lord. Therefore, my lord,
So after second round, no conflict.
no conflict.
Yes, right, sir. Now the area of difference comes about, or the reason for the present cost comes with the infusion
Yes.
and the method you have adopted.
Yes, Your Lordship.
According to them, there are two defining effects.
Yes. I'm
One,
coming to that.
we are not on the consequential seats.
Yes, sir.
We'll call it the casual vacancies.
Yes, sir. I'm coming
You
to that.
you offered the infused seat only once.
Yes. Now, Your
Then
Lordship,
you exited them.
exited them by operation of law, they get exited.
Which law?
Law in the sense, not the brochure, notifications.
Which part of the brochure?
That will come. Your Lordship, you can take page 135 of the same paper.
Yes, sir, 135.
Well, when they entered the second round, well, after enabling the option entry, last third, item 3, well, instructions for entering the options, that there is a consent. They have to click that. They are agreeing for all the conditions and giving their consent to go further. Then, my lord, Your Lordship, we can see the 4, next page, 136. We also say, my lord, seats.
We see is item number 1. The seats available for the second round of seat allotment will be announced on the KEA website. It is advised to check KEA website from time to time for the availability of the seats, as the seats which are cancelled,
Forfeited, newly added, will be announced from time to time.
newly added,
Yes,
will be announced from time to time.
That's also next 4. That's so I'm going to go 4.
With this information, you ask them,
Yes.
after the enabling of the option entry portal and after agreeing to the terms and conditions, can carefully reorder their options in order of preference by logging into portal and confirming fields.
Then, my lord, 4, we say, Lord, the new seats will be added. Seats that may become available due to reasons that may arise during the seat allotment, or seats that may be cancelled after the publication of the seat matrix, or seats that may be newly added to the seat matrix will also be considered for allotment. So all eventualities are not met in the software also. Then, my lord, the note down. Consequential vacancies that arise during the allotment after the candidate merit term cannot be claimed. Then this should be read with, my lord.
This is where Mr. Vivek is arguing to say, in the second round, those which were out of the infused, the newly added seats, which were available, were in fact open to them on rebound also, but this time it was not there.
No,
That's the case.
that procedure itself was done. I'll come to that. Now, my lord, your lordship, I'm at page 139.
All right.
This is not instructions of choice after second round of final seat allotment results, medical, dental, Irish courses. Number 2, candidate must get admitted to the allotted seat. Hence, candidates and parents should enter only the college's option they want to join. As the seat allotment is done on the basis of merit and considering the options submitted by the candidate, the allotted seat cannot be denied. Therefore, candidates should carefully submit the options in the order of priority. Next, failure to pay the fee or take admissions in the college after the second round of the seat allotment will result in legal action against a student. Candidates who are not allotted a medical seat can participate in the medical mop-up round as per the instructions in the schedule. Now, my lord, what I say is, once they select a seat, go and join a college, all their other my lord, this thing gets obliterated. They enter 100 options. In the second round, they admit and go to the college. There, my lord, the other options which they are entered will not be available for them. If they want to go for further round, then they have to cancel the seat and then submit the cancellation should be done to the KEA. Then they can go. There is a penalty clause.
Where do we get that?
Yes, sir. That now you must kindly see the penalty clauses. It was there in the brochure also, page 65.
Yes, sir.
Yes. As per Rule 12 of the Karnataka Selection of Candidates for Admission to Government Seats in Professional Education Institutions, Rule 2006, a candidate who has been allotted a seat in any discipline in the first round or in the second round and who has reported to the college wishes to surrender, cancel the seat before the last date notified for entry of options for the second extended round. Casual vacancy, that's our extended round, casual vacancy, mop-up round we mentioned. The executive director shall deduct 5,000 as processing fee and refund the remaining fee paid.
So even after taking admission,
Yes,
they want to participate in the
next round, before the notified date, they have to surrender. Then
when you say before the notified date, meaning
before the notified date, the candidate who has allotted a seat in any discipline in the first and second round and who has reported to the college wishes to surrender or cancel the seat before the last date notified for entry of options for the second round. Entry of options will be
in this, tell us in this context, which is that date?
the third round. Before the entry of options to third round.
Tell us that date, which is that date? We have dates, so tell us.
Yes, sir. I'll give a date in a moment.
Tell us those dates.
Because that is for the. Well, just in a moment. Then, my lord.
So we are considering. But take your point.
Yes.
That is, they could have cancelled before a particular date.
Yes.
They would have only lost 5,000.
Yes.
And they would have been entitled to participate for all casual vacancies, consequential
That basket. Why we say so is, my lord, before that cancel, because it should go to the.
So please give us that date.
Yes.
You should be certain about the date.
Yes.
We'll stop here. Give us the date so
Yes.
that we don't miss it.
Yes. That is, my lord, 7th October. Option entry open on 7th October. For the third round.
But there was no
It
addition
it was open from 7th October to 13th October.
13th. And all the extra seats were only after 30.
Yes.
Starting from 30.
Yes.
13,
All
16,
these-
17.
All these were created, cancelled. All seats will go to that box. And option entry for that box will start. So they can enter option. Here, my lord, when they go and admit it to the college, their option ceases. They did not cancel, their option ceases. Suppose, my lord, I ask myself this question. If there's 443 that have not to come, you are reconciled with the fact that they are admitted to the college. It's a fortuitous circumstance 443 came. When 443 came,
So they are saying, Mr. Ramesh, yes, fortuitous indeed.
yes,
But then you should have applied the same rules that was available for round 2. And you could not have applied a new rule. They did not know that the seats that opened up because the others gave up,
yes,
that would be available, but not an information that we could have known.
That's what, my lord, they are now, there are two different, my lord, players which they have. One, they want all the seats For all the seats, my lord, I have to enter option entry, open option entry.
Yes. This argument for consequential, we understand.
Yes.
This is for consequential. Now, on the second segment of their case, the second segment is infusion is 443.
443.
You should have had the same rules as you had for the second round.
Well,
That is the
there, in which event I could not have finalized the on the counseling process itself. What happens is
For 443 seats, if you have done 2 rounds, as you have done for other seats,
no, what we have
that is
no,
the case.
see these 443 seats are in the third round. The third round children who have entered, they are also entitled for these seats. Now, in the bargain, what had happened? The merit melod has taken a rule now, because these students, these children who are before the board, they are less meritorious than those students who have entered options in the newly entered options. They are all meritorious.
sir, whatever, if you have done 2 rounds at 443 also, by allowing others also to participate along with this candidate,
Merit would still be. Merit would
everything
still
would have been fine.
No, of course not. This merited candidate.
It is their case. We are still to
That is
form
the
our
case.
opinion. That is their
Yes, that's their case. But my lord, for
Just
for consequential seats of
Ramesh, can we, to get the perspective, can we ask you, sir, why did you adopt what you adopted?
my lord, we are hard pressed by time.
One.
Time constraint was there, and my lord, this bringing them again. Some seats will get vacated. Others will claim these seats. It will have a cascading effect. We should go on and on. That is what I said so in my statement of objections. This was taken note of by this honorable court also after division judgment. There shall be some finality at some point of time.
So you adopted this approach, A, because the classes are already begun and you had to finalize admissions. Second,
Secondly, the cascading effect.
how do you explain that?
That may not
Or
suppose
rather elaborate that.
the 443 students they leave some seats. But now there will be other students who have not got these seats. They will be interested of first and second round. They will also come and claim. I cannot then they leave some seats. Again, those seats will somebody will be wanting that seat. He may come and establish, no, I don't have the benefit of that seat during that point of time. So therefore, we have
Time and cascading.
cascading it.
Third one is you're still holding them to the requirement that you had published day one. Yes, that on 2 aspects. One, if you choose in the second round, you will be bound by.
Yes.
This is just an opportunity for you to avail the infusion benefit.
Future benefit. Only for 443. We asked them only to, well, that's why. Otherwise, they would have continued their option entry. We did not, because they are already holding a seat with them.
So what is the significance of this option entry?
Significance of option entry is, it's a one-time option entry. They choose all the colleges, the government college, private, everything will be there. They can go according to their merit, they assess, they put. Then, the computer will go on, according to their merit, it will go on. If the seat is available first, it will give first. If seat is not available, it will go to the next. Like that it goes. Then what happens? It stops somewhere, they get a seat. After they get the seat, there is what is known as they have to enter a choice. Choice 1 means, I am happy with the seat allotted, I am going on. They choose choice 2. Choice 2 means I am holding this seat. I hold this seat. Till further I go for the second round. Second round they go. Second round they get a seat.
All these have all these have chosen choice 2.
Choice 2. They have gone to they have entered option when options were rearranged. They can rearrange the option. They can't
Go over the option. But they can
They can rearrange. If the new college comes, they can enter that option for that. Then take the seat, they go to the college, they get themselves admitted. Once they are admitted, not all these options goes.
If they have to come back into the race, they have to cancel.
Cancel and enter options. Third round, these people cannot enter options.
They enter options, enter fresh options.
Fresh options. For those seats also, if they want to claim.
They enter,
Yes.
so their right to make other options
Yes.
is only upon cancellation
Cancellation of the seat.
not otherwise.
Not otherwise. Not otherwise. So then we restricted this 11 came. Yes, these people didn't have the benefit of these seats at that point of time. We open up. So this is another, because we also feel not that it should be, merit should be the criteria. So by the time it came, when it came, it did not come at the beginning, Milord. Our option entry for the third round has already started for other students. We never imagined these seats will come. Your Lordship may kindly see, Milord, the
Yes.
now, Milord, we have issued
Just.
I'm sorry.
Yes, please.
Page 141, Lord, is the first notification for third round seat allotment. 6/9/2025.
144.
1411.
141.
610. There, Milord, 145, Your Lordship. Till, my Lord, we issued this, we never had an inkling that some seats are coming. Everything was sailing smooth. They have gone and joined the colleges. We are expecting the third round students to enter option entry started. When option entry started, my Lord, first one, my Lord, batch of this thing, seat matrix was issued by the government for about 4 colleges. Like that, Lord, it didn't come at once. Totally, my Lord, it came up to 443 seats.
It came in 3 tranches.
So, my Lord, we have to, my Lord, our option entry is already started. So
Option entry date, sir, is?
option date not the 310, I have just 16,
Yes.
610 to 1310,
610 to 30.
1310.
Yes, sir.
So during that process, my lord, I have to tide over the situation and also, my lord, give the benefit of this to the other students also. So we ask them only to enter fresh options only for these things. This can't be an arbitrary exercise. I can't open up their whole seats anticipating, my lord, that they take a claim for consequential seats. If they have to do it, they could have done it before entering the.
That is why you rely on what you call the cascading effect.
Yes, cascade. If they were really not interested to go for the third round of counseling, those consequential vacancies, they could have challenged it well before that. They did not do it. It is only, my lord, now when the challenge, listening to this challenge, only after, my lord, I run the thing and provisional list was announced. Now they wake up, my lord, I want that seat. This is unreasonable. Now, my lord, I'll see what happened, my lord, during the process. But after the first and second round seat allotment, for the third round, I had only 377 seats. That's all I had. I could have finished it and these seats came. All those 377 are consequential seats also. And these seats came. These people left some seats. That also goes to the consequential. And these students who have newly entered students, they have also entered options for these.
At this stage, we paraphrase your case like this, sir, subject to what you will say. One, on the consequential seats, they do not have any right because it's been consistently made known to them that they will have their right to participate will end with their choice in the second round. And if they want to come back to those consequential seats, it's only on cancellation. That's the first.
And in the consequential seats, see, some of the consequential seats may be much better seats than what they have opted in the second round.
Yes, that's the consequence. That has been taken note of by this one.
The same logic should apply here also.
Yes. The second, insofar as the second grievance is concerned,
Yes.
Well, they would lose out on some better seats was still a possibility. That was there then, that was there now. And if you are asked to do what they want you to do, then there will be a cascade. There will be no end to the cycle of corruption.
Yes. Then now I have also produced, along with the statement of objections, these results of these 440 PCs. I made separated for results of 440 PCs. Let my friend show one infraction with regard to the merit in this.
Which one do you want us?
That is annexure R5A, page 25 of my statement of objections.
Yes, sir. That runs into multiple pages.
Yes. This is the provisional seat allotment list of 24/10/2025 of only these 443 seats. We made a separate for the purpose of penning. In
Now,
this,
you will next go to the consequential seats, including those that remain unoccupied,
Unoccupied.
yeah, or untaken. That's the final run.
yes, that's
So they also, we would take it that they will not find fault in the sense something has gone wrong here.
No.
They are saying the procedure adopted is
yes. The procedure adopted, they should have adopted this. What procedure was there? The same thing could have been continued.
should have.
Could have been. So in this ballot, in this 443 list, all are merited students. There are more merited than the petitioners.
They have no quarrel with that. Their quarrel is that your next Mopup will be based on this without a right to participate in the seats
No,
that
this is
opened
third.
up with the others taking.
Yes, others taking. That is their grievance.
That's it.
That is their grievance.
So they are not going to pick. They are not going to pick holes in this list.
That is their grievance. That's not the case. That's the grievance. Well, if I had to do that, I would have given a go by to the merit also.
If regulation 17 were adopted, nobody would have had the benefit of it also. And this litigation also.
Everybody would have. Yes, nobody would have.
We will, before we say concluded and we say when our opinion should be, we'll ask them whether they are filing in writing or not, or whether they are sitting on fence.
We have
Yes.
all of us.
That's all right. We'll take it at the end.
On this issue, my lord, this honorable one is, my lord, the Supreme Court has had an occasion in a Madhya Pradesh.
Sir, how do you meet the arguments by Mr. Naik and Mr. All of them together, relying upon paragraph 16.4 directions of the apex
of the apex code in the
Power.
there, my lord, and say only this. That judgment was rendered in the context of post-graduation. Post-graduation accreditation is something different from the accreditation of the colleges in a medical MBBS. Then every discipline counts. Suppose one person gets blood radiology, he leaves. Some other person has got blood surgery or other, he will stake a claim for that.
So what you're saying is upgradation in the case of, in the context of post-graduation has a different connotation. And in the case of MBBS, upgradation only means in terms of the institution and the fee impact.
Yes. And apex bodies regulations for PG is different and UG is different. GMER regulations of the for UG, PG EMR regulations for UG. That with great respect, that can't be equated with this selection.
You're saying don't telescope the directions of the apex code given in the context of PG
Context of
courses to the undergraduate.
Yes. Now, my lord, I have the latest judgment of the Honorable Supreme Court. I have collected some judgments. The first, okay, my lord, page 2, I'll read page 2. It's a Madhya Pradesh High Court judgment. May I read the judgment, bro?
Now, this this is in the context again of the consequential seats. In the context of
Yes. This was taken up to Supreme Court. Supreme Court has.
it's like this, not in a lighter way, but to make the point. When we stake high, but we know what we are entitled. They stake high. They know.
And then I know.
They stake high. Consequential seats also we are entitled to, but casual vacancies in the infused seats we should not have been denied. That's all.
Para 7, my lord. This was taken to Supreme Court. Supreme Court heard.
No, this is on.
That is on one. Page 1.
No, this is on the consequential vacancies.
So once they are not entitled for consequential vacancies means, my lord, they are not entitled for any seats. In the third one.
No, but logical.
And my lord, along with the statement of objection, I have also filed one more, my lord, of this honorable court. What lord it is? His Lordship Justice
Annexure.
Jain Patel, page 87 of this. One of the, I think that may not be there. 87 of
87.
Title bomb. Just now I. This makes an interesting reading, my lord, because the court goes on to say even the merit at that point of time is relevant. Because till not the other day we were buying form by this. Para 8 your lordship candidate. Seven and 8, rather.
So you want to draw parallels in reasoning,
Yes.
even for the casual vacancies, even for the casual. So ultimately, your case is one. You have not compromised on the merits.
Yes.
You have not deviated from the salience of the procedure that are published. And if they did not have a right to seek participation in the consequential seats, they cannot insist on a right on casual vacancies in the infused seats after they were given one option. That's your.
The whole crux of the case is only that. As your lordship rightly put it in the beginning itself, whether they are entitled for a consequential vacancy.
Now that consequential seats gets a new dimension insofar
Because
as
of this, yes.
infused seats and one casual vacancies within that.
Yes, within that.
Instead of 2 rounds, you have done 1 round. That's all.
Yes.
Has the same effect.
This at the most, the lordship may kindly say not 1 round for only this seats. It's a benefit which has been given. And we did not offer a bubble. We asked anybody interested, you come. That is our notification start. You are only interested, you come. Otherwise, don't come. After coming, having fully known that they are entitled only for these things. Now cannot turn around and say, I want that seat.
No, that's it, right? That's it, right? We have casual vacancy seeking. ಅವಕಾಶ ಮಾಡಿಕೊಡ್ಬೇಕಿತ್ತ ಅನ್ನೋದು ಅಷ್ಟೇ ಪ್ರಶ್ನೆ.
2023 we allowed this for third round. But they cannot. That was found fault with by this honorable court.
That is for consequential.
Oh, yes.
Now we are speaking about casual vacancies. They're only on casual vacancies.
Casual vacancy arose, my lord, out of this 440.
Correct. Casual vacancy means
No,
only that.
it was never given to them. We never opted. We have never even assured that. That will go to the consequential vacancy basket.
Yes,
That is.
yes.
With my lord's kind permission, please, my lord, if my brother colleagues on the same
Yes,
side,
Mr. Sagar, in reply.
please, my lord. My lord, the counsel for KEA, sir, specifically sought for any issuance if there's discrepancy in Exhibit R5A, my lord. That is the first list. May I please point that out, please? In the process of their allotment, even in the third round, first and second, where there is a blatant discrimination forthcoming from their own exhibits.
Yes, sir.
And I take my lord to please annexure R5A, which is filed by the KEA, my lord. And in that particular annexure, may I invite my lord's attention to serial number
This is not a,
203.
this is not, Mr. Sagar, this is not a tutu meme. They said something, it's a dare, I take the dare. No, sir.
No, no.
Build your
That is not my
argument on
intention.
anything that we will consider.
My lord,
Now,
it's
you build your argument, we will hear you, sir.
right, my lord. They
Don't
have
say it's R5A, they said, let them point out, now I will point out. No, sir. Point out, build your argument.
My lord, I state that there has been discrimination insofar as that certain students have been given two opportunities even in the third round of those students who had participated in the earlier rounds, but the petitioner specifically has been denied that benefit, and less meritorious students have been allotted a seat to which I was entitled, my lord.
Mr.
May I
Sagar,
please-
are you saying, Mr. Sagar, are you saying that some of those have been permitted, some of them have been permitted, will be permitted to participate in both the consequential seats and the vacancy, the consequential vacancies? This is
I am-
just, the mop-up is yet to be held.
No, my lord, I'm saying
Mop-up is yet to be held.
I'm saying that they have permitted people to participate in the casual vacancy within the third round.
But Mopup has been held and results are announced. For all.
All the,
Yes. That is the consolidated list. Provisional list has been announced. Consolidated list is
for both the consequential and the vacancies.
that is the last 7.
They have, are you saying that some who participated in the 443 seats have also been permitted to participate in the in the next round, mop-up round?
Yes, my lord. May I please just establish?
I did say that.
Just a minute, let him come. Yes, then. All right,
And
sir.
hence, may I invite my lord's attention, please, to serial number 203 of
Take
annexure.
it, as we understand, Mr. Ramesh is not disputing it.
I will not dispute. Because my lord, what he's trying to say.
Let him finish. Let him.
Yes.
Mr. Ramesh is not disputing it.
I not dispute.
Having permitted certain students to participate that way, when I have also participated in the same manner, with a rank of 1,21,000, there are students with ranks of 1,23,000, 26,000, 27,000 that have been allotted seats. I sail in the same boat as Mr. Nayak, my lord. I am only restricting myself to the newly added seats.
All right, sir. All right, sir. Yes, Mr. Ramesh, before we wind up.
Yes. No, no. See, that's why, my lord, I said the results have on the third round results. First, they have given the results of this.
No, his specific allegation is that he has been discriminated against, whereas similarly placed persons have not been discriminated.
No, it is not.
And discrimination is
It is not.
because those people have been, those similarly placed, unlike him, are permitted to participate even in the
If at all the participant, they must have not cancelled the seat and
they have cancelled and then come in the mock-up. Even if any anomaly is shown
yes.
of that kind of participation as an anomaly, it must be only because they have cancelled the
Yes, and if the statement is if
yes, will consider. Yes, madam.
Milords, the first thing, Milords, they never permitted anybody to cancel it. And even what my learned friend showed, Milords, was they were permitted to cancel, but they never told us until 6:10. Whether my lordships will accept my submission or not, I will stick to it, Milords. Until 6/10/2025, they never told, Milords, if you cancel, you can participate. They told you can cancel, but if you cancel, you can participate was told only on 6:10 after we joined the college. My first limb, and I leave it to your lordships, I
No,
will not go.
Don't throw something in the open.
So,
If that is
may take this for a moment.
just a
Where my
minute,
learned
just a
friend-
minute, madam, just a minute. Now, page 65,
65. Could I read it again, my lords?
madam, that is published on 22nd of January 2025.
Shall I read it again, my lords? If a candidate who has been allotted a seat in any discipline in the first round or the second round and who is reported to the college wishes to surrender or cancel the seat before the last date notified for entry of option for the second extended round or casual vacancy round, the executive director shall deduct 5,000 as process fee and refund the remaining fee.
So you're saying it does not run
Yes.
further to say
Further.
you will be permitted to, all right, we'll consider.
That is not at all there in the brochure. It came up for the first time on 6/10/2025, which I took your lordship in my reputation.
It's also here. It's also here.
And then 6:10, 150, page 150,
Yes.
was the first time they said eligibility for participation in the third round. Candidates who are not allotted any medical seat in the first and second round, and candidates have cancelled medical seat by forfeiture of caution deposit can participate in the third round if they are interested in the available medical seat. Those who are not who have been allotted medical seat in Judy can participate.
This is for your participation in the consequential seats.
Consequential. So I stick to that submission.
We'll consider.
Well, apart from that, Milords, my learned friend said it is a cascading thing. I'll make just 2 minutes of submission. They did something like they allowed, Milords, everybody to participate for 9 colleges, 443 seats in the first round. They blocked our options and they let others to continue for the second round, which, my lords, included all the options, which is the consequential also. Now, my lords, they could have done this in one single round and the merit would have been maintained by giving us the option of 9 colleges, permitted us to participate in the same third round, giving everybody
Their
else.
only response is, you did not have a right to participate in the
Milords, I'm not
That's
talking
their
of,
only
Milords,
response.
I'm not talking of consequential. I'm talking of only 443. Milords, I'll make my submission again. For 443 seats, the 9 colleges, if they had permitted people like the petitioners to enter option, only 9 colleges. I'm not talking of consequential. And put us in the third round. All the others in the same third round, giving them option of everything else. In one single round, they would have finished this, Milords. Your Lordship, may I repeat again? Third round, the petitioners would have only 9 colleges, 443 seats. I will not have option of entering other colleges. The other people will have option of entering all the colleges. I will be permitted only, I can take option only in the 9 colleges. But if they permit all of us to participate, my lords, I will be entitled to those seats which become vacant in only these 443. And there would not be a second round that would be necessary. 9 colleges for the petitioners, all others, all options open in the single round. They could have done. There would not be a cascading. And any person, my lords, in college A, seat number 1, my lords, would be taken by rank number 1. If rank number 1 goes to this, the consequential, the rank number 2 will go. My lords, within, my lords, us round, they have created this merit discrepancy which they admit because of this. This 443 which got vacated because they were given option of other seats, my lords, was not given to us. And if it was a single round, immediately the computer would have rearranged and it would have given me. I will not have the right to participate in other colleges because I have a option entered only in 9 colleges. The others have entered option in, let's say, 100 colleges. It's not of my concern at all.
All right.
That is my submission. Well, it would not have a cascading effect and it would be in line of merit.
We take this as your reply, submitted
In merit.
reply.
Well, I would not trouble your lordship. The merit, my lords, has suffered because of this. And they do not, my lords, dispute that.
You're saying they should have done better. They could have secured the ends of merits better.
And
Therefore, we must direct them to do.
in a single round, my lords, when the final list, my lords, should be in accordance with the merit.
Is it all part of your pleading?
It is.
Take us to there.
Para 10, my lords, we'll start with para 10.
Take us there. Take us there.
The petitioners noting that in the third round,
They should have done this. They should not have done that. They should have done this.
my lords, we realized this only after they told us what they've done. But we knew something is wrong. But my lords, the procedure was explained only before this honorable court by
So realize only after the announcement of this.
only after the announcement of result, my lords, we
Nobody knew
realized
this until they put up their
this
case
was
before the
submitted
court.
only on 31/10.
Yes.
When they gave options to us who are already taken seats, we have been given option to only select the few colleges where new seats have been opened. We are under the impression that we are considering it for only these seats. But they allowed new entrants for that. That is where,
New entrants were already there. They were already there.
no, because
Yeah,
the
we
new
have
entrants
options.
were there, because third round has commenced.
We knew only on 30th.
Therefore, my lord, after considering all these things, that's the reason I have produced the order sheet. Lord, court division bench made a specific question to the KEA. The order sheet is recorded. We do submission. But kindly have a look at I have produced the order sheet also. Page 3.
Yes.
Look, we queried the Learned Council for KEA to demonstrate A, under which authority only the candidates who had participated in the first and second round of the seat allotment were made eligible to make online application for the third round, was therefore 43 seats. And to demonstrate under which provision of law fresh registration for the third round of counseling was permitted. These are the two questions specifically put to the KEA by the division. Now, with regard to the first point, the Learned Council has pointed out that the Karnataka selection of candidates for admission to government seats for the Professional Education Institution Rules 2006 is applicable, and the exercise for the third round of counseling was undertaken by them in compliance of the rules of 2006. As regards to the second point, the Learned Council for the KEA has fairly submitted that the rules of 2006 do not provide for such an eventuality, but given the situation arising out of the additional seats being created, the KEA was left with no option but to formulate a procedure for counseling allotment of such seats. Therefore,
Just a minute. 67.
Therefore, my submission is not only the candidates, even they were not aware of the procedure on that day. My submission is, since first and second round, our fates are seats. These seats were taken, introduced in between. I submit to Lord, in view of the law laid down in the case, Lord, we should have been given, these first and second round candidates should have been given an option without entertaining the new advocates. If that was done,
Please read the second part of question 5A.
to demonstrate under which,
No, 5B, that is 5B. Second part of only the candidates who had participated in the first and the second round of allotment were made eligible to make online application for the third round, the 443 seats. So only for these first round, second round participants were permitted to participate in the 443 seats.
no, they are not all. That is how all. That is how it
That's why we are asking you to tell us about the question. Because under which authority they did not say only you two participate. You two in the sense first round, second part. Everybody
they have all.
everybody they are voted. But when it came to the second part, the mop-up round, you were excluded, the others were considered. So this question, you invited our attention to it,
Yes.
but in recording that only the first and the second round candidates were permitted to participate, make online application, QA 443 seats, we wanted clarification. That's not the
No,
case.
I just referred it to say
That's
nobody was aware.
That's not the case. The case is 443, you one and second round, the new entrants, everybody else
Everybody.
participate.
Yes.
After the first stage, you are excluded and the others continue. So question,
Only one thing I have to add. Sorry.
what Mr. Sagar said.
No, that cannot be, see, that is bound to happen. He says his client has more merit. But he is referring to a consequential seating. Not the 440. And one thing, not what I say, that this stopping them at second round is not for the first time. Though we are doing four counselings now, even now we are doing four. First, second, third or mop-up and this way. This was being done from the previous year.
Minus the infusion.
Yes.
Minus the infusion.
So this stopping is there from the beginning. It's not for the first time it is.
Minus the infusion.
Yes.
This time with the infusion,
Yes.
earlier times without the.
Without.
Sir, can you file a better version of the third mop-up round medical seat, which is produced along with your affidavit on 7/11/2023?
Yes.
You have produced some kind of a representation which was pointed out by Mr. Vivek.
Yes.
On 7th of November, you have filed. Can you file it as a flow?
Yes.
We'll give you liberty by tomorrow. Tomorrow, day after.
I'll do it. Tomorrow.
You have annexure 3 to the affidavit. There is some numbers.
Yes, sir, I will.
but that doesn't give it as a flow, a chronological flow, so that the numbers are there. Because you have given 443, then you have shown some arrow, this, that, and all that. Please find
That a flow chart prepared by director. So what the flow chart,
chronological.
First round, second round.
yes. That's right.
Next.
That's right.
Who is excluded?
Chronology.
Yes.
Chronology.
That's it.
And it's also out of place to mention here. In fact, the students who are affected, they have also filed a writ petition for this honorable body. It was tagged along. But ultimately, these were disposed of. Those questions was also disposed of, saying that you await the decisions.
I had filed those petitions.
He said,
Students who are affected by stopping this works, we are all students who have we've been allotted a seat in the third round of counseling. All of us, some of us have let go of seats from other counselings, all India counseling and other state counseling, and chosen to continue here by a written submission.
Shouldn't you have made a memo?
But I had filed a petition, but
Mr. Patel.
if you're also good, my lords, perhaps
Mr. Patel,
yes,
are you before the regular roster bench?
no,
Then, what are you doing, sir? What are you doing?
lords, there, my lords,
Are you helping the cause? We should ask you. You're not before the regular roster bench. You work out your remedies.
my lords, my petition is closed, my lord, saying
Work out your remedies. What can we do?
only for reference, my lords.
Sir, we are a constituted bench. We are a constituted bench. You should know. Yes, the memos are filed. Mr. Vivek, so we will take it that you have no quarrels with. This you adopt? All of it. No, Mr. Nayak is already here.
My lord, my colleague is
reserve
also
fund.
filing.
to this honorable court, subject to the outcome, to complete the process, now we are already overshot all the timing. The direction shall be issued, my lord, to the NMC as well as NCC and to the, of course, the university is not a party. So all stakeholders to extend the time for them, we have to upload after this thing. We have to upload the spectrum of admission to the NCC. That's the time schedule. That is also overshot. That's what we thought that has to be.
Yes, sir. What Mr. Ramesh is saying is, given the litigation that has been, a direction must be issued to say, don't disapprove the admissions. In simple words. Two things. He would assume in his favor and say, and he would assume against him and say, let there be a there will be a time-bound compliance. Even then, there will be a spill out. You will not cite that as a reason to
disapprove the admissions made by this.
You want to say something?
No, lords, let there be an order to that effect.
We will make an order.
Need to follow.
We will make that an order. Assumes against him, assumes in his favor. Nevertheless, There will be there will be nevertheless furthermore time required, which will add on to a further delay, add on to the delay that could be, and that you cannot point out to disapprove admission.
Students will be in.
Yes.
Otherwise, my lord, even both the judgments, my lord, time has been stipulated for completion. In either, when the repetition is allowed, a time is stipulated to complete the rest of the redoing exercise.
Whatever.
Yes.
You will not, you are a party to the present proceedings.
Yes.
And you are also the author. You will not cite this delay as a reason. The litigation period as a delay to refuse approval for the admissions is this last submission, which we take on record. He's saying no nazarandas from their side, let it be an order from the court, because the court's shoulders are wide. The submissions are completed, and the learned counsels for the petitioners have also filed memo as in terms of the liberty reserved by this court on Regulation 17. First, certain additional compilations are also filed and they are taken on record. Shri N.K. Ramesh, as the learned counsel for the KEA, is called upon to furnish a fresh flow of the different rounds with all the necessary details by day after tomorrow. Day after tomorrow, but data. The petitions are reserved tentatively 1st of December.
ಅವಾಗ ಆಪಾದನೆ ಮಾಡ್ಕೊಂಡು ನೀವು ಸ್ವಲ್ಪ ನೋಡೋದು ಆನ್ ಮಾಡ್ಬೇಕು.